Thanks, Megan. Good. And I'm an attorney with the Maryland Volunteer Lawyer Service. I'd like to take a couple minutes today to introduce life estate deeds and highlight a few of the main things a homeowner should know about them. A life estate deed is a legal instrument that allows you, as a homeowner, to determine who has a legal right to live in your property today and who will own your property when you pass away. It can be particularly useful for keeping a family home in the family and for avoiding the probate process. However, this product is not right for everybody, so it's always best to consult with an attorney before signing a deed. The first thing you need to know is that a life estate deed creates a form of co-ownership between individuals known as the life tenant and the remainderman. The life tenant is the person who lives in the home and has the right to possess the property for the rest of their life. As long as this person is alive, the remainderman cannot sell or transfer the property to somebody else. When the life tenant dies, the remainderman automatically has full legal possession of the home and can choose to live there or sell or transfer the property. How much control of the property the remainderman has while the life estate tenant is alive depends on the type of life estate deed that is created. There are two types of life estate deeds. There's a life estate deed with powers and life estate deed without powers. A life estate deed with powers allows the grantor, or the person who has formed the life estate deed, the power to change the deed in the future. They could sell or mortgage the home or change the remainderman. This type of deed keeps the most power with the homeowner who's granting the deed. As a result, if the grantor applies for Medicaid to pay for their long-term care, the property will be counted as an asset for Medicaid. This means that the Department of Health may later place a lien on the property to try to recover any Medicaid funds used for the grantor's long-term care, which could result in a loss of the home. In contrast, a life estate deed without powers is one in which the grantor, or again, the person who's forming the life estate deed, gives up their power to sell or mortgage the property. In this case, the life tenant wants to sell or mortgage the property or change the remainderman on the deed. The existing remainderman must agree to that change. This type of deed reduces the power a grantor has over their own property. One advantage to this type of deed is that the property will not be counted as an asset for Medicaid purposes if the deed is executed more than 5 years prior to the grantor needing Medicaid assistance for long-term care. And in this case, the property is protected and can remain in the family. A life estate deed transfers property differently than a will. As mentioned earlier, a life estate deed is a form of co-ownership that takes place as soon as the deed is executed or signed. When the life tenant passes away, the remainderman, who was already a co-owner, automatically has full possession of the property. In contrast, if a property owner leaves their property to someone in a will, the transfer of ownership is not automatic. For the person who's receiving the property to legally own it, an estate must be opened for the deceased homeowner through the Register of Wills, and after the estate is fully probated, then a deed must be executed to transfer the property to the person named in the will. The nuances of when a will or a life estate deed is the best product for an individual are too complex for this short video, but know that there are some instances when a will may be the better option, such as if a person would like for their home to be sold and then the proceeds split among multiple friends or family members. Now that you've been introduced to the life estate deed, you may be wondering if one is right for you or someone you know. Here's the phone number for MVLS's intake line. Please contact us if you'd like to be connected with one of our volunteer attorneys to discuss your estate planning and whether a life estate deed may be right for you.